Welcome back to Inclusion Revolution here on Eastlink TV. I'm Tova Sherman, your host, and pleased again to welcome Krista Daley, the CEO and Executive Director of the Nova Scotia Human Rights Commission. When we broke, Krista, we were just discussing whether or not you have a legitimate issue, but we went now to the next step, which is someone in employment, for instance, will use the visually impaired idea. The boss isn't really conducive to providing them the necessary playing field equalizers, as I put it, to accommodate them as their vision, for instance, deteriorates, and they're afraid the boss will fire them, and it's getting a little heated, and they make an inquiry to you. As the first thing you told us, which I really appreciated, was you were very educated and informed people taking those calls and really assessing the situation individually, and not just sort of kind of brushing everyone aside. And sometimes there's always been a certain reputation, which is probably unfounded to some extent, but calling human rights commissions overall being somewhat futile for some people. And I think that the fact that you have this incredible first contact is extremely important to the process, and I congratulate you on that. So let's say they've really identified that there's something here that we need to address. Tell me about some of the steps.
Okay, there's a few steps after that. Nothing, it's not that easy a process necessarily.
And so it's not one way or no way, and I get that.
That's right, and it's very nimble, and it really depends on the case, but basically so the people on the phone, they make an initial assessment. Is there just anything there? Right? At which point the person is then asked to fill out an intake questionnaire, and that is in their own handwriting, or they can type it, it doesn't matter to us, but where they basically express their issue. And so it's in their own word, it's in their own language, it's also what do they want out of it as a result.
And it's done in their own time. We have to acknowledge that, because they can write it and put it together and think about it. Nobody's saying come in my office and do it in 20 minutes. And I think that's very important too, because everybody has different time needs to put all that together.
That's right, and we encourage, if people need assistance with doing that. Some people really need to come in and talk it through with us. They don't, for whatever reason, have their own wherewithal to do that, and so they need to sit with one of our staff. But once
again,
that's
an option.
And that's an option, and we put that out, and we find that's an important part, because it's also quite intimidating. Some people say, well, it's another form, and there is a degree of legalism to the form, so it's really useful to say, don't be intimidated. All we need to know here is, what do you want? What's your desire at the end of it all, as opposed
to... Now, they don't require a lawyer to be helping them with this, because you're really an advocate on their behalf in that sense. Because sometimes I do have people saying, I'm going through this human rights process, I would like a lawyer, and I'm often deferring them back to you, because you are their advocate, you are not the issue.
Well, I wouldn't say quite that we're their advocates, so we don't necessarily act on their behalf,
but looking at the holistic situation.
Very neutral.
Thank you.
Very neutral, and our staff really understands that role, that they are really almost to find the truth in all of it.
Correct. So they have to be
impartial
in a mediation process.
But the real challenge that we have, and what we continue to work on, is really keeping the process to a point where people don't need legal advocates. Ideally. And that's making sure that the forms are in a way that is plain languaged and understandable, and that we have guides that explain it all. And once again, that on the phone, we're more than willing to explain it. So if a person's filling out this questionnaire, they phone in, they say, I don't understand question 5, and we just explain, talk about it, and help them and guide them. And so we find that very useful.
They filled out their form.
Yes, they filled out their form.
With all the supports possible.
Oh,
they
absolutely.
Filled out the form.
It then goes to what's called an intake analyst, and at that point, once again, we are conferring with the employer. And we're saying, look, we've now heard formally from the person. It's no longer just a phone call, but we've heard formally from the person. Do you have anything to say about this issue? And we give them the basic facts that have been put to us. And at that point, we offer up almost immediately, do you want to go to mediation?
Right.
And it is, your viewers may find this interesting, majority of cases based on disability and employment situation actually resolve themselves through mediation.
Which is fantastic.
Yes.
Because another one of the misnomers, I think, in the community about your process is that it takes forever. But in fact, if mediation comes in fairly quickly, does it not?
Very quickly.
And since majority of these issues tend to get resolved in mediation, I think that it's important. We also inform our viewers that this perception that this could take forever is not necessarily accurate, considering most cases are resolved within the mediation mediation process.
That's
which
right.
is one of the early processes in the complaints.
Yeah, and that would usually be in the range of sort of 8 to 10 months after that first phone call in, whereas really if you go through the complaint and then an investigation and then to a board of inquiry, you're looking at more in likelihood of 2 to 3 years.
Right.
And
even 8 months sounds like a lot, I think, to a lot of people, doesn't it, Krista?
It sounds like a lot, but at the same time, you really want to make sure that the issue resolves itself properly as well. And one thing that I've discovered in the human rights field is that people also have to be at the right point to resolve, or it becomes an ongoing issue.
Correct.
So let me give you an example. A person with a disability in the workplace then feels that they want to resolve the case very quickly, and that they really haven't resolved the bigger issues within it.
Understood.
So yes, they've maybe perhaps been given some compensation for what had happened, but they still don't feel that there's been a proper resolution to the broader issue.
And the question is, are they ever going to feel necessarily that level of resolution depending on what their needs are?
Absolutely, and the same with the employer. Like, did the employer simply just give the compensation in order to make the thing go away, or did they truly understand what the issues were, and therefore there's an awareness? And so in the area of human rights, maybe more so than other legal processes, there's also a sense of that the two parties have to be in the right place and time to truly
Understood.
Resolve and not to come back later, because a worst case scenario for me is where there's continual complaints in the same area, right? So you resolve it the first time.
Or a premature mediation.
Exactly. And
Understood. That's a good
phrase for that. And then
then
they go back to the. No, I like it. It's because then they go back into the workplace. They think everything is going to be fine. Something else happens. There's another complaint.
So we've got to make sure the resolution is not just about that necessarily that window, but that we've really got a holistic approach to what's going on, and we make sure that this mediation isn't just one piece of a giant puzzle, but actually have a holistic approach to it.
Yeah, and in our world we call that an interest-based mediation, where you really look at the
interest-based mediation. I'm taking that from you.
Thank you. As opposed to rights-based. Rights-based is really like, you did me wrong, you owe me money, you owe me an apology, etc. Or from the employer's perspective, we didn't do anything wrong. So that's all about your right. But interest-based is more about the relationship, and how do you move these two people forward, or these two organizations forward, either if they will never actually work together again in the future, but when they go out to work with other people and in different ways, how do you sort of move the issue forward as well as resolving their own
It makes a lot of sense. So I'm seeing so many, again, I love the holistic idea, which is so many different ways that this can go, and so many different places where you prepare so that this mediation is successful, and your numbers certainly identify that you're doing something where mediation is working in so many of the cases, and I do appreciate that. One of the things you mentioned about money, and I have to say it because I tell people this all the time, you know, often people will feel they've been wrong done by, and we watch a lot of American television. And so we think maybe there's $10 million for a cup of coffee on our lap, or I deserve, you know, hundreds of thousands because in the, you know, on Law and Order that's what he got or something. Do you find that you experience a lot of that? Because I really experience a lot of people misunderstanding the kind of monetary capacity these kinds of mediations have. Can you maybe touch on that briefly before we break?
Yeah, and it's not just the American situation, it's also that even here in Nova Scotia we have the Canadian Human Rights Commission that deals with the federally regulated employers, and those what we call general damages for, in essence, pain and suffering and hurt feeling tend to be larger in the federal sphere than they are in the provincial sphere as well. So here what a person would typically get out of any human rights cases, they may get loss of income, loss of wages, and that really then is very much geared to how much you make, and so that's very
it's very clear.
It's very clear. General damages in Nova Scotia, and that's really the ones for your hurt feelings, your pain and suffering, your discrimination in essence. What that meant to you as a person to be discriminated against tends to top out around $10,000 here in Nova Scotia.
And I think that's really important. I want to say that again just before we break, because there is a perception of what you feel you deserve, and if $10,000 is pretty much the top out, heads up folks, it's $10,000. Now we're going to take a quick break and come back and talk about some of the ways mediation can go, the second half, some of the successes, some of the challenges if mediation doesn't work, and we'll be right back with Krista Daley here on Eastlink TV.